This video looks at what happens after a guardianship and/or administration order is made, including how you can request a review, what is considered a change in circumstances, and the appeals process.
When an order is made, the legal member will determine how long the order is to be put in place for. That can be put in place for up to 5 years. It's important to note that the orders don't just end. At the end of the specified period, the matter will be brought back before the State Administrative Tribunal to determine whether the order ends or if it needs to be extended. This is called a review hearing. The review hearing is quite similar to the initial hearing. At the review hearing, the member will ask you questions about what's changed since the initial order was put in place. They might ask you questions about whether you've accessed some budget and financial counselling, also what support services you're accessing in the community. They will look at whether there's a least restrictive means to operate the order or whether the order no longer needs to be in place.
You can apply for a review of your order at any time. However, we usually recommend that you wait until there's been some positive change in your circumstances. It might be that you've received an NDIS grant to give you additional support, or it may be that you've worked with a financial counsellor to better manage your finances. It's better to seek advice from a lawyer if you'd like to review your order, because a member's unlikely to change your order unless they can see a real change in your circumstances. You can make a review hearing request at the SAT website. This time you'll be the applicant and you will need to provide the evidence to show the change in circumstances. That might be a bank statement, a letter from a financial counsellor or a service provider. In your application, you'll need to provide details of your doctors and your support providers so that the relevant reports can be prepared. A review hearing will be organised about 8 weeks after your application is lodged. If you believe that the wrong decision has been made, then you can apply to have it appealed, and that's different to a review hearing. An appeal hearing is a hearing with a judge and 2 senior legal members. At this hearing, they will consider the criteria for a guardianship and administration order and also consider the evidence that's been provided. At that hearing, they'll also ask you what you want. In many ways, that hearing is similar to the initial hearing. However, it's a fresh look at your circumstances in front of a 3-member panel. Together, those 3 members will make a decision about what orders are required and what those orders will look like. It's important for you to remember that they make that decision with your best interests in mind. The only way that you can appeal this decision is if there's been a mistake in law, and you really need to speak to a lawyer to get advice about whether or not that's an option.
If you'd like to know more, you can check out the other short videos in this series. If you need legal help with a guardianship or administration order, you can contact the Mental Health Law Centre directly on 1800 620 285 or call Legal Aid.